We're going to kick it off so we can get to the fun part afterwards. I'm Jaime Stilson, and I'm here with Eric Sherman. We're both partners in Dorsey's trial group and are very happy to welcome you to today's Bank Roundtable. Really, this is going to be a refresher on what many of you probably know in your regular practice on handling subpoenas, but just walking through some of the checklists that we think about and we use when we as outside counsel are helping clients, including financial institutions, think about the best ways to handle subpoenas. And then we're going to walk through specifically some more recent current events, as alluded to by the title, All the President's Loan Documents. So would welcome that anyone, if you have questions along the way, please feel free to either hop in for those participating through the webinar or to raise your hand like we're in school and let us know. So why don't we dive in? Just as an overview, again, we're going to go over just the very basic framework that we all use when thinking about responding to a subpoena and making sure that folks know just some of the tools that you have in your toolbox when thinking about ways either to avoid answering or, if it is a valid subpoena, things to be thinking about to limit the scope of what has to be produced, what notice is required, that sort of thing. So, we'll walk through governing law. Obviously, where you're at and where the subpoena is issued from are two key issues to always be thinking about. The rule changes in the most recent round of amendments to Rule 45 do permit nationwide service, so it comes from the issuing court where the dispute is. If you're in a civil suit, obviously there are various state laws and in terms of subpoena power that you would need to look at if it was a state subpoena, or as we'll talk about a little bit in the latter part of the program, when you're dealing potentially with some sort of subpoena or other request from a government entity. Then we'll start out with validity. This is something that'll be really important for some exceptions or exemptions to what you need to do with respect to notice from a privacy perspective when you're dealing with consumer financial information. We'll talk a little bit about scope. We'll talk about some of those exemptions, and then we're going to turn to the RFPA and the Trump case, which will be going up to our highest court in the land for oral argument next month. So with that, the first question that you always want to ask when you get a subpoena is it valid? Is it something that, in fact, you must respond to? Some changes to the rule from those of us who've been practicing for a little longer. One that I don't think is a procedural defect could really stop a subpoena, but one which is required is that you do have to give notice to all litigants in the case when a subpoena is going out to a third party. It is a procedural defect that people can raise. It's also one that's very easy to fix. That, however, can give the parties in the case an opportunity to step in before the subpoena even gets to the third party to object. Service, an issue that has been frequently litigated, is really what delivery means in the context of Rule 45. I think most practitioners, as a general matter of course, use the Rule 4 concept of service and actually reach out and try and get people to accept service of a subpoena, but the rule is actually silent on this issue. So always something to think about. My practice, if I am representing a third party as an outside counsel and there is a valid subpoena, the first thing I do, usually, if my client agrees, is I reach out to the party that issued the subpoena, introduce myself. Because the sort of time to object or respond is quite short, I usually ask for an extension, and you'll usually get one as a third party. But also, you can sort of work through letting them know that, if they've reached out beforehand, you can accept service, that sort of thing. So it's one of those things where thinking about all of those issues, are you going to contest it, are you not, are things to consider as you sort of move through the subpoena process. Just as a side note, obviously if the subpoena compels an appearance, there are fees that are technically owed to the witness if it is one for a deposition. that I find that litigants often forget about, but it's one that's required by the rules. Location of compliance, this is another procedural defect which on its face a third party can object to and simply not answer the subpoena in the first instance, is if the subpoena doesn't have a location of compliance that's within 100 miles of where they reside or where they do business. So let's say you've got a case that's pending in Minnesota. Well, actually, we'll reverse that. We're all here in Minnesota. So we're here in Minnesota, but there's a case where a subpoena is issued out of California, and they notice the location for compliance to some law firm in California. On its face, unless they can establish that your client is somehow transacting or regularly transacting business within that jurisdiction, then that's a basis to just simply not respond. Again, is that a procedural defect that's easy to fix? Of course, but it's a tool in your toolbox to potentially get some time to think about what steps you want to take with your client to respond. So, those very basic questions, just looking at the face of the subpoena, are always ones that are important to ask. I think sometimes people kind of slide by them and assume that it's valid, but it can be important when we talk about some of the exemptions that apply to clients and to financial institutions on the notice requirements if the subpoena is asking for financial information from customers or consumers. So next question, are there limits on what you have to produce and who pays? I find that in working with clients dealing with third-party subpoenas, especially when they don't have a stake in the case, when it can be very costly in some instances to respond to the subpoena, you really want to think right at the outset about whether or not there are ways to push back on the issuing party in terms of the scope of what's being asked for, and also letting them know pretty early on that if it is going to be a substantial production, that your expectation is that they are going to share in the burden of the costs that are associated with actually complying with that subpoena. So the rules, latest round of amendments, as I'm sure you all know, because they've been out there for a while, do have some teeth in them in this respect that really third parties have been able to use quite successfully in both limiting the scope of what you have to produce, but also in really pushing the other side to threaten, if that's what you need to do, or get them to agree that they do need to share in some of the costs. And the costs, we'll talk a little bit about what those costs can be on the next couple of slides, but that framework's very important. One of the other more recent amendments to the rules, which we don't have here specifically on the slide, is just to think about Rule 26's proportionality arguments. Those same principles apply in the subpoena context. It's another tool that those responding to a subpoena can use to really focus the issuing party on narrowing the requests to things that are essential for their case. I've seen that done very successfully by third parties who really don't have a stake in using kind of the dual threat of Rule 45's teeth on burden, as well as proportionality as a way to really limit the scope. Another thing to think about as you're thinking about scope is, is there a way, if it's asking for consumer data, to anonymize the data, to provide the data if it's in, some sort of civil context where they're just looking, for numbers or aggregates, to not get to a point where you do have to issue a notice to the consumer under some of the various regulations that are out there, or run into some potential, privacy or other, protective measures that you need to seek before producing information. So all of those things are things that you really should be asking at the outset. Once you've sort of come up with your plan as to what your approach should be, you have to decide, am I going to object, or am I going to move for protective order or move to quash? That really varies by jurisdiction in terms of sort of the right way to do it. I think both can be done under the rules, but local practices can dictate which way makes sense. I think a lot of people will do the objections, but then as a safeguard are going to move for a protective order if they feel that they're not going to get anywhere in terms of negotiating some sort of resolution on the scope of the subpoena. Objections come fast, so again, that reminder that if you can, right at the outset, whether you're in-house counsel or you've decided based on the scope of the subpoena that it makes sense to get an outside law firm involved, you want to call the other side and get an extension if that's something that you need to do.
And hopefully if the subpoena was delivered to a branch, it hasn't sat on the desk for 13 days before you get it.
Exactly. Or, cry wolf and excuse and hopefully get somebody who's amenable to working with you on the other side, which I'm sure, I don't know, raise your hand, has anybody sort of run into that? Oh, you didn't find out until, 2 weeks after the client received the subpoena? Yeah. So that's always a tough pickle to be in, but I find that if you offer an olive branch in terms of cooperation on getting them documents, usually you can, unless they're really cantankerous counsel on the other side, that people are willing to work with you. So I would say a significant area because of the changes in the rules over the last 5 or 6 years where there has really been some traction in the courts is on the fee shifting point under both Rule 45 and some state laws that are similar. There are some where have gone so far as to say, and we gave some citations here, that that sort of shifting can be mandatory, but there are factors that various courts will consider in different jurisdictions about what you need to look at in order to determine whether it makes sense to shift the burden of those costs to the litigant that's actually seeking the information. Obviously, if it's one small file, from the bank's files that isn't going to be more than a set of PDFs subject to some redaction, maybe it doesn't make sense to seek costs. But if you end up in a situation where they're asking for, large volumes of transactions, email, or frankly, just a subpoena where the breadth covers multiple areas of the business, those are all things that you want to think about when advising the other side that costs could creep up very quickly if you have to go to the ends of the earth that they're asking for. So there really is some good case law out there that will support fee shifting. One important area where litigants have pushed and been successful is actually on ESI, both with respect to vendor costs and attorney review time. It's certainly not across the board, but if you get in a situation where the subpoena is going to require collecting custodial files through email, through electronic documents, and actually getting some sort of contract attorney team to actually look through emails for responsiveness, there is good law that is being developed out there that supports asking for the litigant who's asking for that information to, again, compensate for that time. That's true with respect to attorney's fees in terms of negotiating, scope, confidentiality, all of those things. These are issues that really over the last several years, we have a couple of case sites on here, the Niche case, the Ling Long case, where litigants have been successful in convincing courts that they should be awarded some of their attorney fee time in responding to a subpoena. I think that's always a calculus. Obviously, if you decide to take that issue to the court, you have to pay your attorneys to actually bring the motion. So looking at the overall cost that it's going to, that the client will end up bearing in bringing that motion is always important. But I will tell you that the Ling Long America's case here on this slide, they actually not only sought, fees in terms of the negotiations around the scope of production, but they were also awarded fees in bringing the motion for fees. So it can be done. Does that mean that it will always be successful? No, but it's an option for folks to think about if, again, the scope of the subpoena is substantial. I laughed when Eric and I were putting this together. Obstreperousness is definitely his word and not mine.
I think it is, isn't it? Yeah.
Well, I'll leave that to him.
Yeah.
But again, yeah, obviously, the but here is just to warn folks again that it can backfire. If you push too hard and you're really sort of fighting the fight, not to really limit the scope and the fees that your client is doing, but to just sort of be obstructionist, then you may end up in a situation where you won't get all of those fees back. We included the second case just as a warning. Some judges apparently don't like big law being involved, so don't go out and get the most expensive firm if it's a very basic subpoena where it doesn't make sense for those fees to be attached to whatever it is that is being requested in the scope of the subpoena. And you can see, obviously, from this case, the Agrinox case, that the award was slashed substantially. They did get some fees, but certainly not all that they might have thought that they were entitled to get. So I'm going to flip it over to Eric, and who's going to wrap up on sort of state subpoenas.
Yeah, so we've been talking about, basically civil subpoenas in federal court up to now, governed by Rule 45 of the Federal Rules of Civil Procedure. But of course, federal courts are not the only source of civil subpoenas. A lot of civil subpoenas are issued out of state court. And we only have an hour today, so we're not going to do a 50-state survey of all the various laws and rules enacted by states that govern dealing with those subpoenas. There are statutes in various states that are specific to financial institutions. It'll help you shift those costs onto the parties issuing the subpoenas. And then in many states, of course, there is fee shifting just generally for third-party subpoenas, including here in Minnesota, where you're entitled to reasonable compensation to be negotiated in advance for the time and expense involved in preparing documents. There's also that sort of rule under the CPLR in New York. Now, Jaime had, alluded to the overlay of various regulatory concerns that come up when you get a subpoena. We'll just touch on those because generally, the receipt of a valid subpoena, and to emphasize again Jaime's discussion of stopping when you get a subpoena and making sure that it's in proper form and enforceable. Generally, the receipt of a valid subpoena is kind of the key that unlocks you out of those regulatory boxes. So, for example, the Gramm-Leach-Bliley Act, its privacy rule, which would generally, prohibit you from disclosing any non-public information about a customer. If you get a valid subpoena, that's an exception to the privacy rule, and you're good to go. The California Consumer Privacy Act is something that, has been top of mind for folks since it recently became effective. That's another area in which if you have a valid civil, criminal, or regulatory subpoena, then basically your concerns for compliance there are satisfied. So what are the landmines as far as the scope of your production? Again, in state court, in a lot of states, the answer is you're not going to produce anything until the customer's been notified. And states, the way states deal with this are too diverse to cover, all 50 cases in this hour session, but there's a variety of legal authority in states that touches on this, up to and including in some states the state constitution. Way back in 1975, it was held by the California Supreme Court that Article 1, Section 1 of its state constitution required a bank, to keep private customer financial information and to notify the customer of the nature and pendency of proceedings in connection with a subpoena before disclosing any records. And of course, states have enacted various statutes. Some require the bank to notify the customer and to wait a certain period for production. Some states put that burden on the party issuing the subpoena, and others still put that burden on the party serving, but require the financial institution to collect proof that that notice has actually been given to the customer. And of course, in some states, there's some teeth to these regulations. And sanctions can be sought against the financial institution if they don't follow them, including one case out of Louisiana that we looked at where the district court imposed a $10,000 award for certain records that were disclosed in the context of a divorce proceeding. Now the appellate court ended up reducing that award, but those statutes oftentimes can have, teeth, and so you need to watch out. Now, any discussion of, the scope of production for national banks would be, we'd be remiss, and well, all banks would be remiss if we didn't talk about the Bank Secrecy Act and, the obligation to detect and report suspicious activity and the privilege contained in federal regulations that protects those suspicious activity reports and documents related to them from production, from even being mentioned or discussed in a response. And so that regulation provides that you can't disclose a SAR or any information that would reveal the existence of a SAR. The first part of that's easy, The suspicious activity report itself is easy to identify. The law is still a bit unsettled and being worked out as to the breadth of the second part of that, information that would reveal the existence of a SAR. Generally, it's held that documents that indirectly suggest the existence or non-existence of a SAR are encompassed in that. That would include drafts, emails, other communications reflecting the decision-making process. Do we have to file? Do we not have to file? Documents, from after the filing that explain the content of the SAR or rehash it are covered. The underlying facts, transactions, and documents which led to the filing of the SAR are not covered generally. So your canceled checks, your statements, your wire information, whatever it was that led to the filing of the SAR, just the raw transactional data, pretty easy call that that's itself is not covered. Kind of some of the items that are currently on the margins are policies and procedures that banks maintain, to comply with this regulatory duty. Courts have gone both ways on that. You can look at Norton versus U.S. Bank, which is actually a case that our partners Peter Ehrlichman and Sean Larson Bright handled out in Washington State. Was very protective of those policies and procedures. The Washington Court of Appeals overturning a decision denying a protective order that was aimed at protecting those. Down in the Southern District of Florida, within the last 2 years, you had a court take the opposite view, that Norton was too broad and that actually general policies and procedures without any discussion of a particular case had to be produced in litigation in that court. But that law is still unsettled, and so it's still, I think, a fight worth having, whether you're going to produce that sort of material.
And it does bear mentioning that these are always the sorts of things, just like attorney-client privilege, where, whether or not there is going to be a fight depends on how litigious the party seeking the information is. I've found generally in my practice that with third-party subpoenas at least, even though technically they can require and often do in the subpoena indicate that you are to produce a privilege log, most folks don't. And so you may not know if documents have been withheld on that basis. So there's always a calculus going on, I think, behind the scenes in terms of how you respond, at least for me when I'm working with my clients with a third party, to produce as little as possible. You want to comply with the subpoena. You want to do what you need to do in order, obviously, to provide responsive information to a validly issued subpoena. But the more you can do up front to negotiate the scope and to avoid having, for example, to produce a privilege log where you may have to disclose that you've withheld documents on the basis of a SAR privilege or attorney-client privilege or any of that, the better off you may be, hopefully, in avoiding fights down the road. It's also a good reminder that Again, coming back to some of the changes, at least under the federal rules, if you're fighting about those things, where do you have the fight? The rules have changed, and I think people forget this sometimes, but the Court of Compliance is now, a court of compliance that's within 100 miles of where the entity either resides or regularly transacts business. It's not necessarily the issuing court. Now, the entity can consent to have the issue heard by the issuing court because that's where the litigation is actually going on. And a lot of times it makes more sense to have the judge in that district hear the dispute because they're going to have better knowledge of the case and the facts and whether or not the information that's sought in the subpoena really is relevant to the claims or defenses. But that's another strategy call that you have to make when it looks like you're going to end up in a dispute. So now we're going to turn to the act that really underlies the Trump case that Eric's going to walk through in a little bit, and the contours of it, how it came about. And obviously this is in the context of the Right to Financial Privacy Act, which applies to the federal government. This is not private litigants. This is something that is focused just on the federal government. But what they have to do if there is an inquiry that is made by a federal entity to a financial institution. And based on the RFPA that was entered, that became effective in the 1970s, you cannot obtain customer records from a financial institution unless they first get a search warrant, consent, or, number three, some other procedural device such as a subpoena that notifies the customer that their private financial information is the subject of a federal inquiry. Again, it was enacted in the 1970s, really in response to a Supreme Court decision, United States v. Miller in 1976, where the court held that bank records are not subject to privacy protections under the Fourth Amendment. So really one of the early statutes that set forth specific consumer privacy protections in response to a ruling by the Supreme Court that those protections weren't afforded by the more general framework under the Constitution and the amendments. Again, obviously one of the most important points of the RFPA from the financial institution's perspective is that there must be customer notice. There has been some case law out there and some courts have held that oral communications between the government and a financial institution concerning a customer's accounts are subject to the requirements of the RFPA. So you need to be really careful if there's some sort of voluntary communication going on between a federal governmental regulatory body and a financial institution, and those can happen. If that is happening, the bank needs to stop and think, can I do this? Have I given notice yet? Or not have I given notice, but has notice been given to those underlying customers? That brings us to the next point. Notice is the responsibility of the government, not the bank. The way that the bank can figure out whether or not that notice has been given is by relying in good faith on a government's certificate of compliance. You really do want to get that if you're in conversations with the government about specific customer files, that you want to have that in your back pocket. Again, it's another statute where fee shifting is available, always something to consider. The notice requirements are really only directed at customers, not at corporate entities. So it is a narrower definition. You're looking at individuals or partnerships with fewer than 5 individuals. But that does mean, obviously, for financial institutions, that loan documentation, deposit accounts, all the things that you think about where a bank is going to have, an individual customer's private financial information, those are the types of underlying substantive areas where you're going to want to make sure that notice has been given and that you've gotten a certificate of compliance. Question?
Yeah, with the certificate of compliance, is there any obligation to do an investigation to ensure that the government actually complied with it, or can you just rely on?
You can rely in good faith.
Yeah. I mean, if you know in fact that they haven't, that's going to call your good faith into question if you have some reason to know, but you don't really need to go out and investigate and dig around behind it.
Yeah. If there's something suspicious, though, in the way that things are happening, then you may want to stop and think, do I need to press for more? There are obviously, exceptions to the RFPA, anonymized data. This is one that I mentioned that's just a tool in general that you're going to have in your back pocket, but it is a way in various contexts, including in this context, to get around some of the notice requirements. So if the government comes and asks for anonymized data, right, just try to think about where you would see it, but just sort of volumes of transactions because they're looking for statistics or other things versus an actual individual's file, then that would be something that would be an exception to that sort of notice requirement. Cases where the government and customers are both parties, that seems obvious why you wouldn't need to have a certificate of compliance or ensure that notice has been met, because that customer's likely put their file at issue. Not dissimilar to what you might see in with HIPAA, where somebody had something bad happen to them in a malpractice suit or something, and obviously then those types of things go away.
Plus, notice is probably governed by Rule 45 or
correct.
whatever rule is governing the proceeding.
Yep. Security interest filings and bankruptcy claims. Eric and I were talking about this earlier, and he mentioned that one area where you might not think about it is with, for example, aircraft regulations. So a lot of those are governed by, or liens are governed by state law, but require
filing with the FAA.
Filing with the FAA. So things like that. Not that there's lots of individuals out there who own aircrafts, but there are some.
There are a fair number.
Federal loan programs, reports to law enforcement, that's obvious. It's sort of like the general exception you're going to see with subpoenas and otherwise. There are some other regulations that apply with IRS summonses, supervisory proceedings with some of the other federal agencies like the OCC. So there are exceptions out there, but just to be aware of. But generally, when you're talking about sort of the normal commercial or individual consumer loan documents where it's individuals or small partnerships, you're going to want to make sure that you're thinking about the RFPA. So if notice goes out, the customer does have the opportunity, as we will see, to pursue trying to enjoin the disclosure of their records. They can do that in really two ways: showing that the government failed to comply with the RFPA's procedures, or that the underlying materials that the government is actually seeking aren't relevant to their inquiry. If for some reason a financial institution doesn't comply and doesn't ensure that notice has been properly given and that those procedures have been followed, they can be subject to civil penalties, damages, costs, and attorney's fees for violations. There's sort of a statutory violation component. I think it's like $100 per disclosure, but litigants have actually sought punitive damages, not very successfully very often, but just be aware that those things are out there. As we said, by its terms, the RFPA itself only applies to the federal government. But remember, virtually all 50 states have statutes out there that are very similar. So if you find yourself in receipt of a subpoena or some other sort of investigative request from a state entity, you want to make sure that you look at their underlying state law to see if there's anything similar. We've provided the relevant Minnesota statute here, which again requires that the customer be given notice and has authorized the release, or that there are some other ways that the government has tried to validly pursue getting those records through a search warrant or otherwise. So that leads us to a case involving our illustrious Chief Officer of the United States. I'm going to turn it over to Eric to talk about the Trump v. Deutsche Bank case.
All right. Well, it's probably not every day that a subpoena from Congress crosses your desk. At least I hope for your sake it's not every day that one crosses your desk. But since this case has been in the news so much, and because it touches on some of the statutes that govern your work, we thought we'd explore it at least a little bit. This is a case that concerns 3 subpoenas that were issued by committees of the United States House of Representatives on April 11th of last year. 2 of those subpoenas went to Deutsche Bank. One of those subpoenas went to Capital One Financial Corporation. And the subpoenas were quite broad. They sought a range of financial records concerning the president, Donald J. Trump, members of his family, specifically I think his 3 oldest children, Don Jr., Eric, and Ivanka, and then a revocable trust and various other limited liability companies and entities affiliated with President Trump. In response, the president and his 3 oldest children and the various other entities filed a complaint in the Southern District of New York on April 29, basically seeking a declaratory judgment and preliminary and permanent injunctive relief, essentially quashing the congressional subpoenas. The complaint named Deutsche Bank and Capital One as the defendants, and it was basically based on 2 grounds. First, that as a matter of constitutional law, the committees did not have the power to issue the subpoenas, and also that they violated the Right to Financial Privacy Act. The House committees, which were the House Permanent Select Committee on Intelligence, chaired by Adam Schiff, and the House Financial Services Committee, chaired by Maxine Waters, then successfully intervened in the case in the district court. And the Trumps, a couple things to remember about the case. The cases did not implicate executive privilege in any way because they only basically dealt with the president as a person and with his family as a person and sought their personal financial records dating back, I think, some 10 years. And basically everything that the banks had in their files about them going back 10 years. And so the argument that they presented to the district court was, first, the constitutional argument that there was no legitimate legislative purpose for this investigation of the president and his family as private citizens, and more specifically that the committees had not identified any legislation basically under consideration at the time to which these subpoenas would be adjunct, essentially. And then with respect to the RFPA, it was basically, well, look, these committees are a government authority and they can't access the financial records of us as customers unless you jump through the hoops that the RFPA provides. They have to be relevant to a legitimate law enforcement inquiry, and of course the argument was made that Congress doesn't enforce the laws. That's the province of the executive branch. And that you have to have the committees issue notice and go through all the other of the hoops and the 10 days from personal service that in which a customer can file a motion challenging the subpoena under the terms of the RFPA. And so essentially the arguments was that the committees had not done any of these things and had not delivered the certification, et cetera. The committees, well, first let's talk about the banks. I mean, this put the banks, of course, in an awful spot, sitting between 2 co-equal branches of the federal government. And naturally, and I think wisely, after the committees successfully intervened, each of the banks filed through their counsel basically a one-page notice of non-opposition, don't hurt us, we're here to do whatever the court in its wisdom should determine ought to be done. The House committees, of course, took up arms and argued that, first of all, that, look, we're the House Permanent Select Committee on Intelligence. Every intelligence organization within the government, everything having to do with foreign intelligence is within our purview. With respect to the Standing Committee on Financial Services, our jurisdiction includes everything that has to do with banks and banking, including bank and insurance of deposits, including foreign financial transactions. We don't have to have a bill in our hands to support the issuance of a subpoena. We've already legislated, in the Bank Secrecy Act and in other enactments on these topics, and we can investigate how are those existing laws working, right? Do there need to be changes? Does there need to be additional legislation? It's not as narrow as we have to identify, or our enabling resolution has to identify a particular piece of legislation under consideration for us to have this power. And then with respect to the RFPA, the argument was, well, look, yes, the Act covers government authorities within the federal government, but that has a particular meaning. An agency or department of the United States doesn't refer to Congress and its committees, and they basically relied on authority out of the Supreme Court interpreting that identical phrase, agency or department, in connection with 18 U.S.C. Section 1001, which prohibits the making of false statements to agencies, departments, or officers of the United States. And so basically the argument from the committees was the RFPA just simply doesn't apply to us. And in the district court, that argument carried the day. The case was presented to the district court on the plaintiff's motion for preliminary injunction because, well, I suppose this is foreshadowing the circuit opinion, because this had nothing to do with the president in his official capacity. They referred to President Trump in the circuit opinion that we'll talk about in a minute as the lead plaintiff. But it was the plaintiff's motion for preliminary injunction, which the court denied in open court on the record. And I haven't had any success locating a transcript of the ruling, but there was no written ruling on the PI motion in the district court, which would be a little bit unusual, I think, in this district. I don't know if it's unusual for this particular judge, but I forget now. I'm sorry. Did you?
I don't remember.
Yeah. In any way, so it was a standard preliminary injunction sort of analysis where the court held, yeah, you're going to suffer irreparable harm if these financial records, which you have held secret all these years, are revealed. There's no way to, unring that bell. But the questions that you've presented aren't sufficiently, well, it was basically a likelihood. The Second Circuit has kind of a unique formulation of the balance between likelihood of success and irreparable harm. They have what they call the likelihood of success test, where you have to have irreparable harm and likelihood of success to get an injunction. Then they say, well, in some cases, if you don't have that, you have to have at least serious questions going to the merits and a balance of harms that tips decidedly in your favor. And it's really just a way that's different than other circuits in describing kind of the continuum between, harm, the balance of harms, and likelihood of success. And so the district court said that essentially...
Judge Ramos.
Judge Ramos.
Eduardo Ramos.
Eduardo Ramos. And Judge Ramos basically said that the questions that went to the merits of the constitutional and RFPA questions weren't sufficiently serious to support the issuance of the injunctive relief against the committees, and he denied the motion. He promptly stayed that ruling as the case went up to the Second Circuit. And the Second Circuit, I actually have the decision here. It's quite a slog. It's 61 pages between the majority and the dissenting opinion. The panel did split 2-1 on the question, but affirmed the denial of the preliminary injunction. Basically, well, actually, the majority said that they actually didn't get to the serious question standard because of a government action exception within the Second Circuit to whether you can avail yourself of that kind of lower level of likelihood of success on the merits. They basically said, well, you're not likely to succeed, we're done. We're not going to talk about serious questions, and a balance of harms tipping decidedly in your favor. Looked at the statutory question on the RFPA, said, yeah, Congress is not, the sort of arm of the government that is covered by the statute, agreed with the analysis of the authority applying that language in the context of Section 1001. And on the constitutional question, agreed with the committees that, yeah, it's not so narrow as a particular piece of legislation. You have broad authority to inquire, with respect to money laundering, and which was part of the committee's stated reason for seeking the financial records, as well as with respect to the Intelligence Committee's, inquiry into the Russian government's attempts to influence, the political process in the United States, and concerns over whether, because of his financial dealings, the president was vulnerable to exploitation on that basis. I've gotten a little bit behind in the slides here. But so what happened next was that the plaintiffs again sought a stay and were granted a stay of the mandate of the Second Circuit by Justice Ginsburg, sitting as Circuit Justice. And the Supreme Court took the somewhat unusual step of granting review at that point in the proceedings without receiving a formal petition for cert. They basically traded the request to stay the mandate of the Second Circuit as a request for cert and granted it. And the question as to which they have granted review is whether 3 committees of the House of Representatives had the constitutional and statutory authority to issue subpoenas to third-party custodians for the personal records of the sitting President of the United States. And I should mention that the Deutsche Bank and Capital One case was actually joined with an earlier case having to do with a subpoena from the third committee that's mentioned there that went to the president's accountants. And the president's attempts to get that subpoena quashed were as unsuccessful as his attempts to get the Deutsche Bank and Capital One subpoenas quashed. And now that case is set for oral argument before the High Court on March 31st, so it probably won't be very long before we have an answer to these weighty questions of constitutional and statutory interpretation. Anything to add?
No. Any questions?
Any predictions on what's going to happen?
That's not one that I'm going to handicap.
No.
You had a split in the Second Circuit, so it's going to be interesting to see what the justices do with it, I think, and what strains of the competing Second Circuit opinions they pick up. But I'm not sure.
Yeah, I wouldn't place any wagers on that one. We'll just have to wait and see.
Well,
Any
I
other
think-
questions? All right, well, thank you. Thanks very much. And if you're here, please feel free to stay, have a beverage, have a snack. And for those of you who participated by webinar, thanks very much. Let us know if you have any questions.